What is the memorandum of law? We will call it a legal memo or memo because that's a little bit easier to say. This is a very commonly written uh, piece of legal writing, and it's really what happens after you have conducted legal research. So this is the situation, this is the background. Imagine that you have a client with a legal problem. You have conducted legal research to find out which law may apply to his or her situation. You may have found a statute, some cases, etc. And this may sound familiar because we have gotten this far already with your last project. And you will remember that in that project, you took those results and you put them into a form which I had created. The difference this time is that we'll have another project and you will research it. And this time you will take the facts of the client situation and the research, the law that you have found, and you will actually write up your results. So we need to look at how to do that and what the expectations are. So the situation, again, the attorney has asked you to help on the case. Once you have done the research, you will report back to the supervising attorney. That attorney generally will expect you to write something up, to write a memo describing the case. A legal memo uses a technical format that is common in the legal field, just like case briefs, just like any of the things that we do. This has a certain format that we need to learn, and so we're going to learn that now, and then we'll practice by creating one. First of all, let me say at the start that I know if this is your first time writing one of these, you may be intimidated. You definitely may be confused in a few minutes. But I think as you look at examples of how these appear, you'll start to see that, first of all, it's something that you can do. It's definitely something you can do because you've done most of this work already. And all you are going to be doing is turning some of that work into words. Second of all, you may be intimidated, but I think that this is something that we just get good at by doing it, by trying it. And I'm not going to expect you to be perfect from day one, not at all. This is a research class, first and foremost. It's not a writing class. We just have this little bit of writing towards the end of the semester so that we can do something with the research finally. But not having focused on the writing until now, I'm not expecting that you are going to be suddenly really good at it. Unless you took the 72 class. If you took LA 72, then you already know how to write these. So you'll be a step ahead. The rest of you will be a step ahead on the research when you get to the writing course. Okay, continuing on here. What is a legal memo? Continued. The audience and objective. Who is the audience? One person. Your supervising attorney. He or she is your audience. This isn't going to a judge. It's not designed for other people to read, but if they do come across it, or if your supervising attorney sends it around to other people, or if parts of your analysis are going to be used in a later legal document, then it's quite possible other people may read it. But your audience, your target here is your supervising attorney, so you write for that person. Now, this part you really need to pay attention to. It may not make sense yet, but when I've said it once, I will back that up again, and I hope you understand that this is important. Even though your attorney is a smart person, is a legal person, has a knowledge of the law, you will not assume that he or she knows the law, because that's what you're going to be explaining in your memo. You will not cut corners. Most importantly, you will not jump to conclusions without earning the right to get there. That means you need to explain your reasoning, and you need to go through all the steps in our analysis, which we're going to cover, before you jump to a conclusion. You're going to be judged on the quality of your work, not only by me, but more importantly by your supervising attorney in the future. And they want this to be written the way that other people write these, the way that it's sort of accepted in the field. And so I'm going to show you how to do that step by step by step by step. And we don't skip that third step and jump on to the fourth one. We do it step by step by step by step. What's the objective here? To write an informative piece. It's an informative piece of writing, explaining the case to your attorney. You're not going to argue it. It's not an argumentative piece. There's one of those in the LA 72 class as well, but we're not there yet for those of you who haven't done it yet. This is an informative piece. It's here to inform, to predict how things may go. It is not here to argue the client's case, not yet. So the format and tone here, this is an informative writing project. It's not an argument. It's for your attorney, and so your attorney deserves to know everything. The good, the bad, the ugly. If there are facts that favor the opponent, the opposing party, if there's a conclusion that is bad for our client, I don't want you to go the other way. You go the way that this takes you. Do not withhold any facts, and do not shade your conclusion to favor your client. I mean, certainly you can think about it as in the fact, you know, from the client's perspective a little bit, and think about, you know, we're an advocate for this person. What can we do? How can we shape this for him or her? But that's really not our focus here. That's not going to be our focus here. Our focus is what happened. What's the law that applies? When we put those two things together, the law and the facts, what's the likely outcome? Where is this going? And if it's a good outcome, great. If it's not a good outcome, the attorney needs to know that, because the attorney needs to know, maybe in this case, maybe we're not going to fight it all the way to trial. Maybe we're going to try to settle it or plead out if it's criminal. So the tone needs to be honest. It needs to be thorough. It needs to be informative and professional, not argumentative. In other words, we're not trying to win an argument. We're trying to present what happened, because this is for the attorney. The attorney needs to know the truth, all of the truth, and not just the part of it that you want to highlight. Okay. So the next few slides, we'll be looking at the content and structure, and this will take us through a number of different parts here. The memo of law will use what's called the IRAC system of legal analysis, IRAC. That stands for issue, rule, application, and conclusion. Some people use the A here for analysis. That's fine also. I prefer application because it's more faithful to what we're doing. And in that way, the whole thing is a type of legal analysis. That's what IRAC is. So the typical memo format covers IRAC using some common sections. That is, what we're doing is IRAC. We're going through that progression of issue, rule, application, conclusion, but we don't label the memo with issue, rule, application, conclusion. We usually label it with these things. There's a fact summary. There's an issue, which is usually called question presented. Could be more than one of those. There's a short answer. which is kind of like the holding that you're reaching on the issue or question presented. And then there's a discussion. And the discussion, if the rest of these, you knock them out in, I don't know, combined half a page sometimes. Discussion is going to take you longer than that. Discussion is where you're going to go through the IRAC, and that's where the bulk of the work is. So we'll go through each one of these in turn. Facts, question presented, short answer, and discussion. And sometimes you have a separate conclusion after that as well, if there's a lot going on. Okay, so now we continue on to look at these sections in a memo. What are they? Facts. There's a fact summary there. You've done this before. Most of you have taken the LA 10 class. All of you have taken the LA 10 class. I was saying most of you have taken it with me. The fact summary is something that is very common for anything that we write, even when we're summarizing a court case and calling it a case brief. We have a fact summary. So in this section, you will explain the background of the case and what happened. So unlike a case brief, in the case brief, you're just taking that from what the judge wrote in the written opinion. And maybe you're changing that a little bit, streamlining it, reorganizing it. But basically, you're taking what's there. Here, again, since you're not doing the factual research, this is a legal research class, you will take what you're given in terms of the facts of the case, what happened with the client and all that stuff. But this part, I think you can do a good job with. You've had experience with it. Next comes the question presented, and this is your issue statement. Some even just call it the issue. Most of the time in the memo, you'll see it phrased as question presented, which is the same thing as issue. So this is hard. It's hard to find it, hard to phrase it, hard to highlight, zero in on what is the issue and how to write it. So what is the question that you have set out to research? So what's your research question? That may be the same as what you think is the question presented, what you want to answer for the attorney in this paper. Or it may be that once you've done the research, you know more about the law that applies, and you're looking at the client's case. Maybe it boils down to just one thing. Is this true or it isn't? There's a main core of the case. There's a legal question. Maybe you can see, or you can foresee, that there's going to be one sticking point that the parties are going to be fighting about. There's going to be one thing that is going to come up in court that the court is going to have to decide. Any of those might be ways to find an issue, and any of those is a fine approach. Try to write an issue out in one sentence, and that should be a question sentence. We'll look at examples coming up, but you've seen some that courts have presented in cases that you've read and summarized as case briefs before. It's like that. So this time you're going to be summarizing it yourself rather than picking it out of a court opinion. But it may have some very close relation to what the attorney asked you to research as well. Okay. That is followed up by a short answer. When you did case briefs in LA 10, do you remember the holding section of the case briefs? The holding was the court's response to the issue. How did the court answer that issue question? That's what this is. This is your holding. It's where you are answering the issue, the question presented. So is our client likely to be guilty or whatever? Was there a valid contract formed that, the defendant then breached? Yes or no, or probably yes or probably no. The short answer is basically it's going to function as, for a quick reader, somebody who snap, snap, snap is scanning through it with their eyes. They're going to see this probably first, and it's going to be the response to the issue. What's the bottom line here? Well, it's you predicting where this is going to go. You're not arguing, you're predicting, and you're doing that based on the information. So your short answer is going to be short, going to be one sentence, two sentences, and before that we're going to start with a very clear yes or no, or hedging our bets a little bit, probably yes or probably no. So it'll be, yes, our client is likely to be guilty because they did this, this, and this. Or probably no. A valid contract was never formed in this circumstance, whatever. So you can hedge your bets a little bit with the probably yes or probably no, or you can be really clear with a yes or no, and then a sentence, explaining why. But you're not going to do a maybe. You're gonna pick a side here. I shouldn't say pick a side, because that means you're like picking which party you think is going to win. It's the question. It's the question presented, the issue. How do you think a court is going to decide that? What do you think the likely outcome is going to be if we take this into court? And this needs to be honest. It needs to be not just a yes or a probably yes because you like the client, you want to win this case, you want to take it on and do your best. The attorney needs to know if we have a bad hand, and there may be a no or a probably no there just as easily. So again, this is seeming abstract. We're going to see what it looks like coming up soon. Continuing on here, the next section after the question presented and short answer will be the discussion. And the discussion is the heart of it. This is where you are doing the heavy lifting. This is where you are going through the IRAC step by step by step by step, by a whole bunch more steps if you need them, as many steps as you want. You don't skip any steps, and be very, very methodical here. So, while your question presented is your issue, it is possible that you have more than one issue. Okay, right. So you're going to IRAC each issue separately. So in this discussion section, we're going to be talking about this IRAC progression. It's possible that there may be more than one issue. So what I meant here is that, going back to the question presented, well, in a way, you already have the issue stated here. So the IRAC, you've already got the I somewhere in your paper. You don't need to spend too much time with it here. That's one approach. Focus on the RAC. Yeah, but it's possible. And for one thing, it's good to remind people, summarize it here again. For another thing, with the IRAC, it's possible that you're going to have more than one issue. If there are multiple issues, multiple questions presented, and short answers to each one, then in this discussion section, you're going to have to take each one up separately also. I mean, what if there's a contracts issue and there's also a torts issue, and they're totally different? I mean, different questions. Well, you're going to have to IRAC each one separately. So that means when we go through this, I'll show you. Here's a warning. I put it here just because you need to know it at some point. I already mention this warning in a different way. Many students make the mistake of forgetting the A in IRAC. It's just like the A in your grades. How can you get an A on this paper if you don't do the A in IRAC? Well, don't forget it. It's very tempting to jump from explaining the rule to concluding. People jump from the rule to the conclusion. Here's the law, therefore, here's what should happen. No, don't do that. Don't fall into that trap. You need to show all of your steps. Be very, very faithful. And so let's look at what those steps are. IRACing it, if IRAC is a verb here, means explaining the issue. That's the I. And again, if you just have one issue, you've already explained it once, so maybe just highlight it again, remind the reader what it is here once. I'm not going to push you into doing multiple issues this semester, so you don't have to worry about that. But you will be in the future writing these things where you have multiple issues, in which case you probably want to be very clear about what the issue is for each one. So you do want to explain the issue, then bring in and explain the law. That's the R part. R stands for rule, or rule of law. Explain the law. Maybe you found a statute, maybe you have a handful of cases that seem to apply. How do they apply? That's the next part. Apply that law to the client's facts. Okay, so we have this this statute that says you can't do this and that. All right, here in our case, in our client situation, this happened. So in our client situation, this person did that, or this person didn't do this. So you're actually taking that law and applying it to our client's facts, showing how those two things come together. And that's legal analysis. That's the A part. It stands for application because faithfully that's what it is. Or analysis, because in the end result that's what you're doing. But I don't want you to focus on trying to create analysis. What you're doing is you're trying to apply the law to the client's facts and then ultimately reaching a conclusion. That's the C part. And when you have done those things, we can call the whole thing analysis. If there are multiple issues, you may also need an overall conclusion section in addition to this discussion section. Either way, it's not going to be a big section, conclusion. Whether it's part of discussion, whether it's a separate section, which sort of brings everything together that you've done. It's going to be pretty short because you've done all of the explanation already. And so this is just like a little summary of that's where it led you. Okay, you may be confused, probably are. This is new. This is an abstract discussion of it. So let's look at an example of an actual legal memo that uses this IRAC progression. And it also uses these different sections, the facts, facts, question presented, short answer, and discussion. When we look at that, I'm going to pull out those sections so that you can see them. And this also, if you can't see the PowerPoint all that well, you can open up this sample memo, which is in the module on Canvas. Okay, so this is what the beginning of a legal memo looks like. Other than the fact that at the top here I included a note that you can use the same format as this memo. I'm just mentioning that because when you're going to do your own, you can use this as kind of a format model. You're not going to use this as a content model because this isn't your memo. It's not about this Lohmann's Fashions breach of contract claim. Yours is going to be about something else, which I'll give to you later. But this is kind of how you do it with the memo. All right, so at the top there's a heading section, and you can figure that out. It's to and from and regarding and date. I'll probably put that on your assignment anyway. And of course, if you're in a law office and this case says some particular file number, you throw that on there too. So we begin with the facts. Let's look at this one. From the start, I don't care too much about this particular one, this particular case, this particular set of facts. Doesn't matter to me. I'm just showing it to you in terms of the format. So what are they doing in each of these parts? That's what concerns me. We need to understand enough of it to know what they're doing, but I don't care really to understand this particular topic or memo, because it's not what we're doing. It's just an example. Facts. Lohmann's Fashions, I think that's the client for this sample, a retailer of women's and men's outerwear, distributed a circular in November advertising a manufacturer's closeout of designer women's leather coats for $59.99, coats that regularly sold for $300. So I guess this is like a print advertisement. The ad announced that the store would open at 7 a.m. on Friday, November 30th, and stated that the, quote, early bird catches the savings. After about 15 minutes after opening, all the advertised coats had been sold. At 7:30 a.m., a shopper inquired about the coats and was told that there were none left. But she complained that Lohmann's was obligated to sell her a coat at that price. You need to sell me something at the same level, a designer coat at that price. That was the customer's argument. The store manager said no, declined, and the shopper filed a complaint in small claims court alleging that Lohmann's had breached a contract by failing to sell the advertised leather coats at the advertised price. Okay, so it's the C word, contract. Customer is alleging that a contract was formed by this advertisement. It's probably going to be at the heart of the issue. Let's see. Next page. So this is the memo continuing, and the facts, that part was above there. Question presented is the next section, and you can see it's followed closely by short answer. Okay, question presented here. Under New York law, which is what they were supposed to be looking at in this sample, did Lohmann's Fashion's description of a designer leather coat in an advertising circular constitute an offer to sell the coat, which became a binding contract when the text of the advertisement indicated that the coats were a manufacturer's closeout and that the early shopper would be rewarded, and when a shopper signified her intent to purchase the coat according to the advertised terms? All right, all that stuff, that second half of it is facts. What's the legal question here? Did Lohmann's Fashion's description of the leather coat in the advertisement constitute an offer, which became a contract when the customer showed up to claim it? That's really the question there. And so your question presented, your issue could be that. I mean, was a contract created by that advertisement? Did that constitute an offer that created a contract? Because if it did, then it was breached. It was broken. Lohmann's didn't uphold that contract. That's pretty clear that Lohmann's didn't uphold that contract. The question is, was there even a contract in the first place? Probably not, but let's see where this goes. It's just an advertisement, but look at the way it was worded there. So you could just write the bottom line question. You know, was a contract created here? It makes it much more precise. It makes the answer a lot better if you can word into that question some of those facts. And they did it here in great detail. You don't always have to, but that's not a bad idea. The way that they did that, it makes the focus, it makes the answer that much better. So look at the answer here. No. Okay. Done. So we have a yes or no, or probably yes or probably no to start things off with the short answer. And then a sentence, just a sentence, maybe two, but I wouldn't really go more than one here. A yes or a no, or probably yes, probably no, followed by a sentence sort of explaining why. And that's your sort of executive summary for the quick reader who isn't going to read the next part. The next part is where you're really going to explain it. But here is just, it's kind of like a summary of your conclusion, where it's going. But the focus of this is answering the question presented. No, whereas here, the text of the advertisement merely stated that the sale was a, quote, manufacturer's closeout, and that the, quote, early shopper would, quote, catch the savings. The advertisement was not an offer to sell the coat, which could be converted into a binding contract by conduct signifying an acceptance of the advertised term. So they're saying it wasn't a contract offer which the customer could then cash in on as a contract when they showed up to claim it. So they're saying no, it isn't. Why? We have to read on, but that's the bottom line. So this is basically your from case briefs. This is basically your issue and your holding. The difference here is with the short answer, it's your holding. You're not summarizing what a judge has done anymore. This is where do you think this is going? Where would you take it? And that should be an honest place that you have found this. You're not going to be writing this before you write the next section. The next section, the discussion, you probably should write first, and then come back and you can tack on a short answer after you know what it's going to be, because you may think you know what this is early on, and even the issue. You may think you know what that is early on. But it may change as you do the research and as you do some analysis. As you write the discussion, you may realize that it really boils down to something different than you thought. And so here and here, you know, you could pencil them in, but you might come back and rewrite these things or put something in later. Let's go on to the discussion. Okay, so remember this discussion section. I have four more slides here. Issue, rule, application or analysis, and conclusion. It's all going to be in here. The discussion section, you know, we saw the facts are pretty short, question presented, a short answer, pretty short, and this is about as long as I see for those. They could be shorter on many people's papers. Discussion, this is the whole discussion. In fact, I even left some of it out because it got so long. Discussion is really where you're doing the work. So let's start with the beginning of this person's discussion section, and again in this sample memo that we're looking at. Loehmann's Fashions has been sued by a shopper for a breach of contract for its failure to sell a designer leather coat that had been advertised for sale at a substantially marked down price. Okay, so they're kind of summarizing, they're reminding us what has happened and where we are here. Lowlands contends that the advertisement was intended to apply while supplies of the item lasted, and that it is not obligated to sell the shopper a comparably valued coat at the advertised price. Okay, nothing new here. They're just kind of rehashing it, but that's useful. It's really useful if we have multiple issues, because we need to sort of label those separately, and this is going to be crucial to explain each one a little bit. For this paper, with one issue, they probably could have done with less here, because you already, you went through the question presented, you got it right there, and here it is again. I don't really care, but this is good writing. This is nice to sort of summarize it again here. Here's where they kind of get to the core of it. The issue in this case is whether a retailer's advertisement will be considered to be an offer that may be turned into a binding contract by a shopper who signifies an intention to purchase the items described in the advertisement. Okay. This part of the discussion, the issue section, they could have just, this gray part was all they really needed, but embedded into this larger paragraph, you can see they summarized the facts a little bit, and then they did a very dangerous thing here. A court would likely conclude, don't go there yet. I don't want that yet, because you are 4 slides away from a conclusion, and you can save it until there. When you get good at this, and you're not going to fall into the trap of just popping the conclusion on here or popping it on here, then you can do this, and you can put a mini conclusion foreshadowed here. That's fine. I don't need this yet. I don't need you to put anything like a conclusion in here until the end. So it's there, but the issue part, where they're flagging the issue here for the discussion, for the purposes of IRAC, this is fine here. Let's go on. The rule of law. This is where they're talking about what they found as far as legal research. What is the law that applies here? They did a very nice job of it. They're going with case law. That's what they have. You can see they didn't mention, a relevant statute or anything. It's case law, and being that this is a New York case, they're looking at cases from New York courts, New York state law. We, of course, would be looking at whatever law applies to our client's case, and likely in your own memo assignment, it's going to be something dealing with California law or federal. But this example shows New York. So they have these cases they mention. I would probably pretty quickly be jumping into my main case, and it looks like this is probably here, which in this slide I cut off, and I didn't give you the rest of it because they just go on and on. But look at the way they did it. I really like what they did. First of all, instead of just starting with, in the Schenectady Stove Company case, this happened. I found a similar case, and it said this, this, and this. That's fine. That's perfectly fine for the R, for the rule of law section, for this part of the discussion. But they have multiple cases, and they've brought them together for us. Think of having a puzzle, and each puzzle piece represents one case. maybe it's one of those small puzzles for young kids where there's maybe just, 5 or 6 puzzle pieces, but each one kind of adds something. And maybe one puzzle piece is bigger than the others. That's maybe your statute or your main case or whatever. You might be tempted to just start with that. But look what they did. They summarized, after putting those puzzle pieces together, they summarized what they mean as a whole for the law in this state. What is the rule? What is the law in this state based on these cases? And it might just not be from one case. It might be from those cases as a whole, kind of taken together. They give us this picture. This picture would be that the rule is well settled that an advertisement is merely an invitation to enter into negotiations. And is not an offer that may be turned into a contract by someone who shows up and wants to buy something. Good. So they've told us that the law in New York, based on these cases that they've read, is that an advertisement isn't a contract offer. It's an invitation to enter into negotiations. That's the law in the state. Okay, and they're string citing a whole bunch of cases here, which all pretty much said that. So they got it out of one or more of those cases and found it in some other places where it's kind of mirrored. And this is the summary of what the law is. Very nice to start with that to explain that that's the law, and then go into some of these cases a little bit more in detail. The only general test, something more specific. However, a purchaser may not make a valid contract, and nor does the purchaser have the right. Each case is giving me a little bit something more, something different. And they're going to explain a little bit more about the Schenectady stove case, because in that case, the plaintiff delivered to the defendant a catalog of prices containing a statement of terms of sale. Blah, 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 blah. The catalog didn't state the amount. Under the circumstances, the court said, it's not a contract. So, great. They're going to explain that a little bit more, what a similar case or an applicable case, something useful, what happened there, what the court said. So this is our R part. This is our rule of law in the IRAC. We had the issue. This is our R, our rule of law. Then let's go on to what some people think is the hardest part. This is the part some people skip. The application. See what they did back in the R section in the Schenectady stove case. The plaintiff delivered the defendant a catalog of prices. That's the same sort of thing we're looking at here. But now for application, we're looking at what happened with Lohmans, our client. This case, the facts that we know about, what happened here. In our case, in this situation, Lohmans, those would be ways for you to start off applying that law that you just went through to the facts of this case. Lohmans' advertisement did not contain a promise to sell the leather coats. The promise to sell, that came from one of the other cases. That is something that the court said was important. There wasn't one, so it's probably not going to be a contract. Did not contain a promise to sell the leather coats in exchange for some requested active promise. Therefore, the client is going to win. No, don't go there yet. Don't skip the A part. This is important. The A part is how you get an A on this. The A part is important. So there's a temptation for people to cut corners. There's a temptation for people not to go methodical here, step by step by step by step. And this A part is the easiest one to lose because you just jumping right to that conclusion. Don't fall into that trap. You need to, you think your attorney is a smart person, that they're going to follow the logic. Don't assume that. You need to do this step because this is the mark of a quality research paper. It's a quality memo of law. Lohman's advertisement did not contain a promise to sell the leather coats in exchange for some requested active promise. By its terms, the advertisement announced that it had a stock of coats to sell, and it described the coats as manufactured closeout, selling at a reduced price. Nor did the ad give the public an option to choose a comparably priced leather coat if these advertised ones were no longer available. As the court noted in Lovett, bringing in some law there, a prospective purchaser does not have the right to select items that the retailer does not have in stock or is not willing to sell at a reduced price. So they've taken that law and they've applied it to the facts there. They're rehashing those facts, the ones that are important to getting at the heart of this issue, and explaining how that law that the courts in New York had announced from these other cases applies. What does that law, how does that law apply to Lohman's facts, Lohman's situation? And as the court noted in Lovett, a prospective purchaser does not have the right to select items that the retailer does not have in stock. Then they've done that. I mean, honestly, it's just this first part is most of it. The advertisement did not contain a promise to sell, which it would have needed to, according to courts, if it were going to be a contract. By its terms, the advertisement announced, explaining very clearly what was in the Lohman's advertisement. It had a stock of coats to sell. It described the coats as manufacturer's closeout at a reduced price. It did not give the public an option to choose a separate item if this one was sold out. So those are the facts, and applying the law there. And then from that, it's going to be pretty easy to step our way down to a conclusion, because we've done most of the steps now. The claimant here might argue, little counter-analysis. Just in case we were wrong here, little counter-analysis. Not a bad idea. Just looking at the other side. What the other side may argue, can we counter it? The claimant here might argue that the advertisement did not contain limiting language. So didn't see any disclaimers. For example, the coats were for sale while supplies lasted. That would be nice. You should have mentioned that. However, the ad indicated that the store, opening for business on the day of sale at 7 a.m., was catering to early morning shoppers by announcing that, quote, the early bird catches the savings. Guess what? That means people that show up late maybe don't. The ad could fairly be read to mean that the supplies were not unlimited. So this is anticipating a counter argument and shooting it down. Again, is this needed here? It's kind of an extra. It's kind of an extra part, but it's nice. Finally, you get to the conclusion. Look how short it is, because you've done all the work. That earlier stuff, the issue, rule, application stuff, that stuff was hard. That was where you did all the work. And so when you get to the conclusion on these facts, the court will probably find that the claimant has failed to state a cause of action for breach of contract. Yeah, basically, it's unlikely that the court would find a contract existed here, basically, because the ad did not constitute an offer, but merely an invitation to negotiate. Where did that language come from? It came from New York law, from the case law. So nice bringing it in there, not changing it, not rewriting it, just that's really faithfully applying the law is what they did in that application section. And here, this conclusion, it's just a summary of where this has gone based on that analysis. And so you don't need to do new analysis here. conclusion should be short. You've already done the reasoning and gotten your way there. Now, if you have multiple issues, multiple short answers, then in this discussion section, you would have to go through this analysis, IRAC. Need to do that for each IRAC, for each issue. If there's a torts issue, need to IRAC it. If there's a separate contract issue, need to IRAC it. And then you might need a larger conclusion section. Label it, conclusion outside of this discussion or outside of the IRAC part, and then that's where you sort of summarize result of any conclusions that you had. Maybe if there were 3 issues, 3 conclusions, a tort issue, it's not a tort, contract issue, it is a contract, Okay, well, conclusion is that on the tort thing, there's not much, not likely to You sort of bring it together. You bring those strands together and you have a mega conclusion. But here we don't need one. You can just have the conclusion as part of the IRAC of the one issue, and within this discussion, within the one IRAC analysis, and you're done. So that is the memo of law. That's what it is, how to write it, and then we will look forward. My dog is barking. We will look forward to seeing your assignment, which I will put in the module. I may record a little bit more, explaining a few more words about that, but basically this video is what you need as far as how to write that. That's going to be a separate set of client facts. You're going to need to do the research, and then when you put it together, it's going to look something like this. So use your memo. Again, I am not expecting miracles. I know this is a first time for most of you trying to do this, but you also actually did most of it already when you filled out the memo form the last time. You know what this is? This is a big memo form. You've got these sections. You just have to write it out what you find. So facts, issue, short answer, discussion, going through the IRAC analysis. So I know it's new. I know it's intimidating. I know it's something different, but you are more experienced in the parts of this than you think. And so writing this up is just another step. Do your best. Let me know if you have any questions, and best of luck with it.